We're now getting word from the government where Kapil Sibal, the Union Law Minister, has released a statement on Twitter. He says the government has filed a review petition on Section 377 in the Supreme Court. He goes on to say, let's hope the right to personal choices is preserved. Kapil Sibal speaking on Twitter there, releasing a statement saying the government has filed a review petition on Section 377 in the Supreme Court. Remember, the Law Minister had earlier announced that the government would be seeking legal options to try and reverse the Supreme Court's earlier ruling. Jaskirat Singh Bawa, our Supreme Court correspondent, is on the phone line for more on this. Jaskirat, the card is now on the table.
Absolutely, and Pierre, we in fact have headlines today just managed to get exclusive access to the government's 36-page review petition. Now, some of the details from that review petition are the fact that the government is contending that the decision of Justice G.S. Singhvi and Justice S.J. Mukhopadhyay suffers from errors apparent on the face of the record. These are the exact quote from the review petition. The review petition is actually very similar in terms of its arguments to what the High Court judgment had said in favor of decriminalizing homosexual acts. So that's basically the crux of the review petition. But now we know now that the government has finally filed the review petition in the Supreme Court. Of course, we will be getting in more details on the basis of the content of that review petition very soon.
And this, of course, comes after there were various suggestions going around about how the government would take this forward. There was a suggestion of introducing an amendment bill, the suggestion of an ordinance, the suggestion of a review petition in the Supreme Court as well. Why did the government narrow down on this particular option? Any clarity on that?
Well, this would have been, judicially speaking, one of the best approaches to actually get this reconsidered. We are given to understand that there is also a building consensus in the legal circles for a larger bench of the Supreme Court to decide on the matter. Of course, the government over here, this particular tenure of the government is on its last leg to bring in an ordinance. Also, to bring in an amendment cannot be brought in anymore because the Parliament is not in session. But to bring in an ordinance was also being considered. However, the most thorough and the most sure-shot approach right now was to go in for a review petition, and that is what they've done for the time being. It is expected that normally review petitions don't usually get accepted as far as statistics are concerned, statistically speaking. But if this does get referred for a larger bench, then perhaps there may be, even though it's a long-drawn legal battle, still there may be some ray of hope.
Yeah, just for viewers who aren't very well versed with how the Supreme Court works, in its earlier ruling, the Supreme Court said this is a matter best left to the legislature and not the judiciary. But in this case, it now goes back to the Supreme Court. You mentioned a larger bench. Help viewers understand what happens in the review petition.
Well, there's no specific request for a larger bench that has been made as far as the review petition is concerned yet. However, that is something that can be expected to happen if, let's say, Supreme Court does allow for a further hearing of this petition. If, let's say, they admit, what will happen right now is the review petition will go in for consideration amongst the judges. The review petition will go in for consideration amongst the judges in a closed chamber, and only after that they may decide that the review petition will or will not be heard eventually.
Does this, the case was fought by the petitioners partially on constitutional provisions. It was fought partially also on medical grounds, particularly to try and restrict the spread of HIV. If it goes to a larger bench, presumably they'd be looking at how Section 377 violates mainly the Constitution more than any other thing.
Well, that is correct. That was the main crux of the case, whether that be in the High Court or the Supreme Court, that the Section 377, the certain parts of the Section 377 of the acts that are within it are actually constraining Article 14, which is the right to equality, Article 15, and Article 21, which is the right to life and personal liberty of the Constitution of India, which are the fundamental rights. So that will definitely, if the Supreme Court does admit the review petition, then that debate will kickstart all over again. We can definitely expect that to happen.
At the same time, the Supreme Court also said in its ruling, when its ruling came out, really, that the defendants in this case had not given sufficient evidence of Section 377 being used to target or to harass people or to harass homosexuals.
That's correct. It is widely being criticized that particular section of or part of the judgment was widely criticized as not being consistent with the track record or not being consistent with what the Supreme Court's role really is.
Right.
It doesn't matter if it's 100 people over a period of 100 years or 200 people over a period of 150 years. Even if one person is sidelined or is being prejudiced against, it is the Supreme Court which is held as the guardian of your fundamental rights and the guardian of your judicial rights. And in that case, it was felt that the Supreme Court probably erred. We also have given to understand that the government's review petition is challenging the Supreme Court judgment part where it said that we cannot rely on foreign judgments or foreign rulings for Indian judgments in the Indian context.